Hello. Unless you're in serious denial, you know that there are bad bosses out there. I'm not talking bad meaning not good at managing people. I'm talking about being bad people. Bosses who touch and who make innuendo and who bully and who yell. Well, here's another truth. There are bad employees too. There are people who interview well but are simply lazy. There are employees who, how shall I put this, are not very bright. And there are employees who are toxic. They dislike the organization, they dislike the department they're in, they dislike your coworkers, they dislike you. They have a chip on their shoulder, and they just went to HR or to the local Equal Employment Opportunity Office with a complaint about you, saying that you don't treat them fairly because they're old, or female, or gay, or a different race, or a different religion, or pregnant. Maybe they're playing a couple of cards, claiming that you're discriminating against them because they're all of the above. The last straw was when you refused to accommodate their request to bring their emotional support animal to work. Seriously? A turkey? Ever had a direct report like this? Someone who you just knew was gaming the situation. Someone who probably knew the HR rules better than the HR department. If you haven't yet, you will. So here's the message of this program. You cannot retaliate against any employee for asserting rights protected by EEO laws. Let me repeat that. You cannot retaliate against any employee for asserting rights protected by EEO laws. And if your pain-in-the-blank employee happens to know his or her rights, and so many of the troublemakers do, you should just assume that you're being set up for a legal claim. What to do? Well, the first thing to do is not be an idiot. What's my definition of an idiot? Someone who does something knowing that the outcome is not going to be good. So don't do anything hasty. The next thing to do is learn the law. Just because someone has a chip on their shoulder doesn't mean that that person cannot be disciplined. For the next 7 minutes, I'm going to talk legalese. I'm going to go over 7 concepts taken directly from the EEOC's publication, Enforcement Guidance on Retaliation and Related Issues. I'm going to introduce some terms that you might not be familiar with, and yep, this stuff is going to get boring, so hang in there and try to pay attention. If you do, you might just have an aha moment, a moment when seemingly different rules and regs start to gel, start to make sense as a set. And that's useful. It will help you be a better supervisor, and it will reduce the odds of you making employment law mistakes. So settle in, take a big chug of your coffee, and listen. No need to write down everything. At the end of the program, we'll provide a link to the EEOC sources and our summary. How does the EEOC, the Equal Employment Opportunity Commission, define retaliation? Retaliation occurs when an employer takes a materially adverse action because an employee asserts rights protected by the EEO laws. Asserting EEO rights is called protected activity. What type of EEO activity is protected from retaliation? Generally, protected activity is either participating in an EEO process or reasonably opposing conduct made unlawful by an EEO law. So what does it mean to participate in an EEO process? Participating in an EEO process means making a complaint or serving as a witness to any side in an administrative proceeding or lawsuit alleging discrimination in violation of an EEO law. What does it mean when an employee opposes a perceived unlawful EEO practice? Employees do not have to do things they think are against EEO law. For example, they don't have to fire a person for a reason that appears illegal, and they don't have to deny reasonable accommodation to a worker protected by ADA rules. But there's a much more common example of opposing a perceived unlawful EEO practice. That's simply saying that you're going to file a discrimination claim based on an EEO right. Now this can get confusing. Is an employee's impending claim of discrimination participating in an EEO process, or is it opposing an unlawful practice. You know what? It doesn't matter. The lawyers can figure that out. What matters is that a manager must not punish someone for complaining or threatening to complain about alleged discrimination against oneself or others, refusing to obey an order reasonably believed to be discriminatory, resisting sexual advances or intervening to protect others from sexual advances, requesting reasonable accommodation for disability or religion, complaining to management about EEO-related compensation disparities, talking to coworkers to gather information or evidence in support of a potential EEO claim. Let's review. Which of the following are protected activities? Marie complains to HR that she didn't get a promotion because she's a woman. Is Marie's claim a protected activity? Yes. Sarah was interviewed as part of an investigation into Marie's claim. Is Sarah's testimony a protected activity? Yes. Jose accompanied Nadia to the Human Resources office where Nadia filed a complaint after being told that wearing her religious headscarf at department meetings was inappropriate. Is Nadia filing a complaint a protected activity? Yes. Is Jose accompanying Nadia as she went to file her complaint a protected activity? Yes. An HR manager spoke to senior management about her concern that the company was improperly denying reasonable accommodations to individuals protected under ADA rules. Is the HR manager's visit with senior management a protected activity? Yes. Wow, lots of yeses here. These individuals were asserting EEO rights, and they are protected from retaliation for asserting those rights. New topic. Are employees involved in protected activities safe from discipline or termination for misdeeds? No. We all have EEO rights. That doesn't give any of us special permission to not do our job properly. But supervisors need to tread carefully. If an employee claims retaliation, the best defense will be written documentation showing consistent treatment of all staff. When is a supervisor's action serious enough to be retaliation? Retaliation includes any supervisor action that is materially adverse. Materially adverse actions include denial of promotion, denial of job benefits, demotion, suspension, discharge. You know, I think these examples are pretty obvious. You're not learning much by me telling you that firing someone might be considered retaliation. So let me show you the other end of the spectrum. In the EEOC's own words, a negative change in behavior toward an employee after an EEO allegation can be perceived as retaliatory. Whoa! What that means is don't start being rude to someone who's made an EEOC protected complaint. Don't start isolating them. Don't start spreading rumors about them. This hostility won't accomplish anything, and there's a good chance that it'll blow up on you. Whether an action is materially adverse depends on the facts and circumstances of the particular case. The U.S. Supreme Court has held that changing the work schedule of a parent who has caretaking responsibilities for school-aged children is materially adverse, as is excluding an employee from a weekly training lunch that contributes to professional advancement. What types of evidence may support a claim of retaliation? In many cases, the supervisor's own statements may acknowledge or betray his or her intention to deter someone from engaging in protected activity. In other cases, different pieces of evidence support a claim of retaliation. Examples include suspiciously close timing between the protected activity and the materially adverse action, verbal or written statements demonstrating a retaliatory motive, comparative evidence. For example, the individual was disciplined for an infraction that regularly goes undisciplined, and clear misrepresentation of the facts by management. I promised to keep the legal stuff to 7 minutes. My time is up. But I'm happy where we are. We got a lot done. Let's summarize. Not all employees are wonderful, honest, and hardworking. That said, no matter what you think of someone, if that person accuses you of violating employment discrimination laws, don't ignore the accusation and don't try to get even, ever. The fact is, there are workers who float from employer to employer, repeatedly making employment law claims. Half the time, their strongest case ends up being the retaliation they experienced after making the claim. And that retaliation claim is a legitimate claim with legal standing, even if the initial claim is determined to be false. So your job as a supervisor is to not get tricked into doing something that a court might see as retaliatory. Instead, get advice. Talk to your supervisor and/or HR. They're there to help with issues like this. Managing people is the hardest job in the world. Avoid any action that can be seen as retaliatory, and your job will be easier. Thank you.